And so with us today, we have one of the most respected legal minds, right? Pete's one of my favorites, actually. I'm here to kind of decipher that issue for us and tell us what any updates are. Pete Solecki serves as the counsel for the Interlink Law Group. He also serves as general counsel for Greater San Diego Association of Realtors and former partner in the law firm Larson and Solecki LLP, which is a real estate business law firm with clients throughout the state of California. So welcome, Pete. So he can give us a little breakdown on this form and any other updates in the risk management field.
Thank you. So this one is a difficult one. As you know, since last summer, thanks to an amendment to Civil Code Section 1102, that's the primary statutory disclosure area of the Civil Code. That's also what gives us the TDS. It comes out of 1102. So they added the fire hardening disclosure, and it's causing us trouble for two reasons. One, because of a difference in interpretation of the statute, and two, because there's potentially a lot of money involved. And anytime there's a lot of money involved, there's the potential for dispute over that money, and that means potential legal action. And the way you solve a legal action with a lot of money is you point at your commission and your E&O insurance, and we don't want that to happen. So let's take a quick look and see what the story is all about. So the section that's been added to 1102 is 1102.19, and I'll just read you the appropriate language. So 1102.19a, I'm just going to cut out some of it, says, a seller of real property subject to this article that is located in a high or very high fire hazard severity zone. That's the key, high or very high fire hazard severity zone, shall provide to the buyer documentation stating that the property is in compliance with Section 4291 of the Public Resources Code. That's the clearance that you've met the property clearance area, and you've cleared the property of any fire hazards and so forth. So the buyer, the seller, has to provide the buyer with documentation stating that it's in compliance. So CAL FIRE reads that and says, end of story. You have to provide this inspection report saying that it's in compliance. Except that the statute doesn't actually stop there. It says as follows, and then there's a semicolon and a little one that says, in a jurisdiction that has enacted an ordinance requiring an owner of real property to obtain documentation. So CAR reads that and says, well, that only applies if you're in a jurisdiction that requires documentation. And there is no jurisdiction in San Diego County that has such an ordinance. So CAR puts out a requirement, a fire hardening form, that says this is only applicable if you're in a jurisdiction that has an ordinance that requires you to provide this form. We don't have that in San Diego County. So according to the form, you don't have to provide it. According to CAL FIRE, they stop at the first sentence. CAL FIRE says, yes, you do have to provide it. It's a point of sale requirement. So we have this interpretation issue where CAL FIRE says it's a requirement. And CAR's form says, no, it's not a requirement. So what do? You got a problem. Well, actually, there's a second portion of the statute, Section B of the statute, that says if the seller has not obtained documentation, seller and buyer shall enter into a written agreement pursuant to which the buyer agrees to obtain documentation in compliance with the Resource Code within 1 year after the date of the close of escrow. And if you look at the fire hardening form, it allows you to come to some agreement where the buyer can that requirement. Well, fortunately, CAL FIRE has loosened their position a little bit, and they recognize now this ability of the buyer to come into compliance and agree to get this form within 1 year. So why is this a problem? Well, it's not as big an issue if, first of all, it's not an issue at all if you're not in a high or very high fire hazard area. So if you look at fire.ca.gov, there's maps in there. If you get your NHD report, you can find out if you're in a high or very high fire hazard zone. If you're not a problem. If you are, obviously you do have a problem. Being in compliance doesn't mean you have to have dirt within 50 feet of your house and nothing else. But it can be a problem depending upon what type of vegetation you have there. And if you have to remove a bunch of trees, it can be very expensive. We're talking potentially thousands and thousands of dollars. So there's potentially a big expense involved. And who does that expense fall on? Is this something where you want to know about it? I think the answer is yes, but there is potentially a big expense if you're in a high or very high area and if the inspection happens. And once you get the inspection, there's some time frames clicking. Once the inspection comes and you fail the inspection, you've got 30 days to make the changes. And then CAL FIRE is going to come back and they're going to re-inspect, and if you fail again, $1,000. 2 weeks later they come back, $2,000. 2 weeks later they come back, $5,000 and a criminal misdemeanor citation. And it goes up from there. So you've got some big problems on your hand if you don't make this work properly. So what do? Well, there's several things you need to be concerned about. As an aside, if you're in a high or very high fire hazard area, one thing you need to think about, buyer's agents, is insurance, period. Is your client going to be able to get insurance for their property in a high or very high fire hazard area? That's become a huge problem these days, or the cost of the insurance has become a huge problem. So you need to be thinking insurance and whether or not they're going to be able to get the insurance. This is not something you can ignore. Here's a statement from the DRE about this fire hazard disclosure. Quote, if you do nothing more than have your client sign the FHDS, that's the fire hardening form, we are concerned that your obligations under California real estate law will not be satisfied. So in other words, if you just have your client sign the form and walk away, you're in trouble. Brokers, you're in trouble because you haven't satisfied the supervision requirement. So this is not something you can just ignore. Let me give you the worst case scenario. You got a lazy listing agent, has the client sign the form, doesn't do any checking. You got a lazy buyer's agent, doesn't sign the form, doesn't do any checking. Forms are signed, a fire happens the following summer, the house burns down. The buyers don't have appropriate insurance. They go talk to their lawyer. The lawyer has them check about the fire hardening form and sees that nothing was done in conjunction with that. They file a lawsuit because their insurance isn't appropriate enough to cover it. They not only sue a bunch of other people, but they also sue the brokerage and the agents. You turn to your GL policy to see if your GL policy is going to cover it. Your GL policy turns you down. Your E&O is not covering this, by the way. Forget the E&O coverage. So now you have your GL policy turning you down for coverage, and you're riding bareback both I'd be a little concerned if I were you. So what do? What's the best practice here? So I think the best practice is not to ignore it. Find out if your client, on the listing side, if your client is in a high or very high fire hazard area. It's easy enough to do. You get through your NHD, fire.ca.gov, you can get the map on there, find out about it. Urge your client to get the report to find out. It may disclose that you've got a problem. If you got a problem, and again, it's not dirt for 50 feet outside your house, you can get some concept of what might be involved in trying to get your house protected and seeing that it's in compliance with the requirements for the inspection. So you get an idea of what's involved. Have your client take a look at the videos. If you're going to agree to have the buyer do this, then have the buyer make sure he understands. And while you're doing all this, both list and sell side, you're documenting it all in writing via emails so that you've got a record of it that goes into the broker file and everything is documented. It's my understanding that the various brokerages are treating this differently in the county. Some are treating it still as a point of sale issue. Some are treating it as a negotiating issue between buyer and seller. So I know that the brokerages, some of you guys are treating it differently. But it must be addressed. It must be addressed. It must be in writing. Make sure it's clear. Make sure your client has an understanding. Make sure all of these issues are addressed. Make sure your client has an understanding of what they're getting themselves into, and that understanding is documented in writing for your file, so that when something bad happens, they don't come back at you and solve the problem via A, lawsuit, or B, your commission. You can kind of expect that anyway, because all problems are solved via your commission, as you know. But at least that's one way to try to resolve this. By the way, the new RPA addresses this, and it addresses this as CAR always has. It treats it as simply an issue that is going to be addressed in the fire hardening form. The latest issue of the RPA, the latest update of the RPA, which just came out yesterday, the paragraph 11 is the statutory and other disclosures. 11C is the fire hardening, and 11D is the defensible space disclosure in the new RPA that's coming out in December. And both simply refer to the fire hardening form and say that it's to be given. So that's how it's treated in the new RPA, as to be addressed in the fire hardening form. That's it. You got to be careful, and this is not something that you can address any way other than dealing with it and documenting it carefully through the fire hardening form and through documentation with your clients. Thanks a lot.